Begin by talking about the very important and landmark legislation, Bankruptcy Bill. The Joint Committee today has given a go-ahead and has put the important report in the Parliament today. It seeks to overhaul a lot of old laws and legislations. How hopeful are you that the Bankruptcy Bill will see the light of the day and will get a clearance from the Parliament in this very session of the Parliament?
This is going to be a landmark legislation, and the Joint Committee had worked with great speed. And we conceived this idea last year, and we prepared the report, and we came up with the draft bill. And it has already been introduced, and the Joint Committee has reported a bill now. I don't think there's any difficulty in the bill getting passed in both the houses, because both the houses have been represented in the Joint Committee, cutting across the political lines, and there is no contentious issues involved here. And this bill will enable a more easy flow of credit into the market, and it will see the rise of bond market. People don't have to depend upon the banks for raising finance. This will encourage a lot of youngsters to go in for a lot of startups. And we also recognize that market failures are normal things, and people should not be penalized if something fails, unless of course there is some dishonest intention. We have structured the code in such a way that asset stripping, siphoning, and things will be things of past, and we are providing for a early detection of sickness. There is the inability to play. We don't have to wait for 51% of net erosion.
Right.
We also provided for a new unique clause for exit of companies,
Right.
which is right now lacking in the existing legal system. So anybody who has started a business who wants to wind up can wind up and go away.
So, that was the very important point that you've raised, and in fact, this was my second question. Starting up is the exit of the business is as important as starting up a business. You're also talking about a voluntary exit clause in the new bill. How important will it be, and what kind of changes does it really involve?
Actually, it's a clause for 59 of the bill deals with voluntary exit of corporate persons. Any enterprise which have started and then they found that it's not viable, they want to wind up. Currently they have to wait for many years for the business to be struck off from the register and get a clearance. So that is a thing of past now. Anybody can get immediate clearance and go away. So it encourages businesses to experiment and take risks in this new scenario. In fact, doing ease of business, this is one of the parameters which have been held against a country in low ranking.
So, as far as cross-border insolvency is concerned, that was something that has been discussed, but I don't know if it is really a part of the new bill. And given the fact that we are witnessing cases like that of Vijay Mallya, how important will it be to enable cross-border asset transactions and insolvency, given the larger picture that we are witnessing at this point of time?
Cross-border insolvency presumes there is an existing infrastructure over which we can have cooperation with other countries. We don't have that right now. We don't have information utilities, we don't have resolution professionals, we don't have a board to recognize their performance and discipline them. Now, once this code is in position, we can always implement this unilateral model on cross-border. It's not difficult. And I am sure with regarding tracing the assets of Indian investors abroad, the committee has already suggested a clause in the bill. I understand. I have not seen the clause. So it's easy to get information abroad from information of assets held by Indian investors. Now, the cross-border insolvency, we can very easily add on to the existing code by a chapter. It's not very difficult. But it presumes that we have the existing infrastructure in position, which was lacking till now.
The fact that, the new bill also provides for insolvency professionals, who will, of course, look at the situation developing in a company, will give them a time frame to look at what really can be done to fix things. Help us understand. You did mention the fact that there should be no loopholes. There should be, a market failure is okay, but it shouldn't. We should ensure that siphoning of money does not really take place. So how does this? How is it that this is going to work? How do you think this new bill is going to take care of that?
Right now, under the SICA BIFER, when we have a debtor getting into indebtedness, he continues to be in possession. But this insolvency code changes the whole scenario. Now, when the insolvency resolution professional is appointed, immediately the management is taken over from the promoters and directors. So, and they will not be able to take part in the day-to-day affairs of the company, it will be done by the creditors committee. Of course, these directors and promoters will be part of the creditors committee, but they won't have a vote. So we are not totally ignoring them, because there is a widespread criticism that how can the resolution professional and creditors can take over a different type of enterprise and run it on a day-to-day basis. But the promoters and the directors will be on the creditors committee to guide them. So we have taken care of it. So asset stripping and siphoning out is not possible because management is taken over, and the detection of sickness is at a very early stage. It doesn't have to wait till 51% of the erosion of net worth. So you find that there is no scope for siphoning off, and these resolution professionals will be tightly controlled and disciplined by the board. So they cannot indulge in fraudulent. Their criminal penalties are attached to them.
Right. Also, help us understand, sir. Many experts who we talk to, they say that unsecured lenders should be given an equal weightage as far as bankruptcy is concerned, along with the secured creditors. Help us understand, does this bill really make a provision for what needs to be done with the unsecured lenders?
We are giving a higher ranking for the waterfall provision. Unsecured creditors are also getting a higher ranking, even the government dues going below them. No, there is a criticism that secured creditors should be given a special preference.
Find us on Facebook at facebook.com/etnow, and don't forget to click the like button. You can also follow us on Twitter at etnowlive. To stay updated with all our programming, hit the subscribe button on our YouTube channel by logging on to youtube.com/user/etnow.